Should a GAL speak for the child or speak over the child? There's an important development in the 2026 Utah legislative session that deserves attention well beyond juvenile court. House Bill 372, particularly its substitute versions, take a serious look at guardian ad litem duties and standards. And while the bill lives primarily in Title 80, the child welfare space, the principles behind it should matter in divorce, child custody, and parent time cases too. Here's why. The proposed changes reflect something fundamental: a recognition that a guardian ad litem is not supposed to replace the child's voice. I've been saying this for years. This bill draft suggests a structural shift. For children 8 and older, a GAL may be directed to advocate for the child's expressed wishes, not simply what the GAL independently believes is in the child's best interest. That's significant because for years, one of the persistent tensions in custody litigation has been this: when does a GAL act as an investigator making recommendations, and when does a GAL function as the child's attorney? Those are not the same role, and when they blur together, the child's actual voice can get filtered, diluted, or overshadowed, or just outright misrepresented. The substitute language also contemplates requiring GALs to disclose the child's expressed wishes in court and even identify the date of last contact. That may sound procedural, and while it is, in a way it isn't, because it reinforces accountability. It forces the system to confirm that the GAL has recent, meaningful contact with the child and is accurately conveying what the child has actually said and in a timely manner. It also expands investigative and oversight expectations: ongoing contact, independent investigation, more granular reporting. Again, not cosmetic, structural. Now here's where this matters for divorce courts. In private custody disputes under Title 81 of the Utah Code, courts often rely heavily, sometimes decisively, on GAL or PGAL recommendations. That reliance can drift into deference, and deference can drift into substitution. The risk is that the GAL becomes the child's proxy decision maker rather than the child's representative and advocate. HB 372, which I've been talking about, reflects a legislative instinct that children, particularly older children, are not passive subjects of litigation. They are participants whose preferences may carry legal significance. How could they not? That doesn't mean a child gets to dictate the outcome. Best interest remains the governing standard. Best interest analysis is stronger, however, when it is informed by an unfiltered understanding of what the child actually wants. Divorce courts would be wise to absorb that principle. When a GAL reports, the court should ensure that the child's expressed wishes and just outright testimony are clearly distinguished from the GAL's own evaluative conclusions and personal biases. Judges should ask, is this the child speaking, or is this the GAL interpreting, or just doing what the GAL wants? There's a difference, a meaningful one. The more transparent that distinction becomes, the more credible the system becomes. Children deserve to be heard, not through lawyers of abstraction, but directly, accurately, and responsibly. If HB 372 moves the law toward reinforcing that clarity, family courts should pay attention, because when the child's voice is preserved rather than overshadowed, best interest analysis becomes more honest, more disciplined, and ultimately more just.